91. So any definition, anything that goes in the Supreme Court rules in 1980 has to be considered of Article 191.
I'll come to that. My short answer.
Kindly you focus on that.
Yes.
What does law mean over
Yes.
there?
My short answer to that.
I think council.
Sir, I'll just complete
no,
my
I
submission.
think council is entitled to argue any which way they want to.
Achha.
Let us hear you.
Yes.
I have to hear you decide what you say, and if we have already formed opinions, we can reflect them in our judgments. Please continue.
Not a question.
Otherwise, we
I'm sorry,
will
this is
never
not a question
conclude
of
these
forming an
hearings.
opinion. This is a question that, as a judge of the court sitting on this bench, I am entitled to ask.
Of course,
counsel.
ask it. Let the
So I'm
council
asking the
finish his submissions.
If I'm interrupted all the time, I'm sorry to say, sir, that is not proper.
I think the interruption
asking-
is of
I'm
learned
asking-
council.
I'm
Tell
asking
learned council,
counsel-
आप आगे बढ़ें.
I am asking counsel a question, which is my right to ask the counsel. If he wants to answer
After
it,
he
doesn't
concludes
answer
his
it.
submissions with
If
the
he
greatest
wants to
of
or
respect.
doesn't want to, that's his issue. That's not my issue. You understood the question now?
My lord, I'll address that question. Let me just finish this submissions on competence and then I'll address this question. My lord, so I think there can be no doubt about what the word law means in Article 191 in the context type. But if your lordship requires a constitutional context, then subject to law also occurs in the constitution, and it has been interpreted by your lordship of what that means, and that has been interpreted as meaning an act of parliament. A recent judgment on this is a judgment authored by Justice Mansoor Ali Shah Sahab in the extension case, which is PLD 2020 Supreme Court, page 1. And your lordships are aware, if your lordships look at 243, sub-article 3, which contained the same language, although subject to law was not in the beginning but in the middle. The president subject to law. And his lordship, Justice Mansoor Ali Shah, in para 27 of that judgment, said this means an act of parliament. So then another judgment, my lord, on this would be the Baskakar case. Now, if your lordship, as your
What
lordships
case?
are aware,
Baskakar.
Ji,
Yeah.
Baskakar.
Okay.
Whether law has been defined in the Constitution?
No. Existing law has been defined.
Kindly see 260.
Federal law is also.
Federal law has been defined.
Ji, law has not been defined. Existing
Federal law
law.
has been
Ji, federal law has
Siddiqui
been
sir, please
When-
continue your arguments.
When 191 says of a law, does it talk of existing law or does it include a law that subsequently may be legislated?
It cannot talk about existing law because existing law is a defined term in the Constitution under Article 260. And that is a reference to Article 268, sub-article 7. So when existing law is used, it's a defined term in the Constitution.
So where it is defined, then the Constitution must have used the term existing law somewhere.
Yes, in
Where is that?
268.
No, वो तो
It is in
defined हुई है
260
ना?
It is in 260.
Other than the
260, yeah.
definition, where in what articles, what other articles has this term been used?
It has been used in 268. It has been defined and used in that, as far as I'm aware. But it is a defined term. So if they wanted to use existing law would have been used.
Mr. Siddiqui, it seems that, albeit the fight is about me as being as a master of whatever, you're not hearing what I'm saying at
Sir,
all,
ma'am,
and you're completely ignoring.
No, sir, I'm not.
I mean, you don't want to make
No,
a
no,
submission.
sir, but I'll
You should just sit down and answer
No,
questions.
I'll complete my submission.
So why
Now-
aren't you making your submissions?
No, my lord, leaving aside the issue.
Mr. Faisal Siddiqui, just 1 minute.
Ji.
You've given the example of Article 243. The President shall, subject to law,
Ji.
have the power to do what? Raise and maintain military, naval and air forces of Pakistan and so on.
Ji.
Well, the difference between law over here is, and this is the point that yesterday was made with other learned counsel, that this relates to a specific entry of the Federal Legislative List, i.e. entry number 1. Law over here is relatable to entry number 1, a specific entry
I'll come
of
to
the
that.
Federal Legislative List. And this was in relation to Article 202.
No, I'm simply saying that the word term subject to law, as used elsewhere, has been judicially defined in a certain, whether Article 191.
There's a context. Yeah, what I'm asking you is
Yes.
there's a context to Article 243, and the context that appears to be missing in relation to Article 191, where there is no specific entry, for example, in relation to the Supreme Court. So, which particular legislative list would you link the use of the word
That
law?
is where I'm coming to, my lord. When it comes to practice and procedure, I will be relying on entry 58. When it comes to, I'll be relying on entry 55. So I'll come to now this submission. I just wanted to clear as far as this word law is concerned. Now, let me come to my first part. As your lordships are aware, there are two parts to this law. One relates to practice and procedure, and then there is section 5 which relates to appeal. Although there is a judgment by His Lordship Justice Munib where he has said as far as legislative competence is concerned, even appeals are a part of procedural law. I'll be referring to that judgment. So, if appeals are also a part of procedural law as far as legislative competence is concerned, then they would even be covered in practice and procedure law. So let me first come to how practice and procedure is covered. My lord, if your lordship may kindly see my note, I rely on entry 58 read with article 191, my lord. Now, my lord, it is, if your lordships accept my argument, which is that subject to law also includes acts of parliament, if I can safely make that presumption, then in order not to make this word redundant, there must be some power with someone to make this law in the Constitution. Otherwise, the word will become redundant. Now, that power, my lord, based on entry 55, it has to be based on entry 58. The reason I say that is entry 55 deals with, as apart from practice and procedure, it deals with jurisdictional powers. When one is talking about practice and procedure, one is not talking about jurisdictional power. I make that distinction. Now, a question was raised as to entry 58. If I may draw your lordship's attention to entry 58. It's quite a complicated entries, both of them, my lord. If your fourth schedule, sir, entry 58. Now, a question arose as to a very important term which is used in both the entries. It is by or under the Constitution. Entry 55 uses the word by or under the Constitution. Entry 58 only uses the word under the Constitution. If I may read, matters which under the Constitution are within the legislative competence of Majlis-e-Shura or relate to the Federation. What does this term under the Constitution mean as opposed to the word used in entry 55 by or under? My lord,